SJC-11357, estate of Stephanie Moulton versus Nicholas Puopolo.
Let's proceed.
May it please the Court, good morning. I'm John Frumer on behalf of the 18 current and former members of the Board of Directors of North Suffolk Mental Health Association, a not-for-profit provider of mental health services. The director defendants are the appellants. No one is here today to debate the tragedy which took place on January 20th, 2011. What we are here today to determine is whether or not the definition of employer in the Workers' Compensation Act is to be read to include directors of a not-for-profit board for purposes of application of the immunity provisions of the exclusive remedy of the Workers' Compensation Act. What I would like to direct your Honor's attention to start with, I believe, is the definition of employers itself within the statute. It says in the first line that employer contains individuals or corporations. It also says that any one or more of these, if they're in a joint enterprise, can be considered to be the employer. We know that the legislature, when they drafted this, certainly had in mind not-for-profit organizations, and by looking at the last line, where they specifically said the word employer shall not include nonprofit entities as defined by the Internal Revenue Code that are exclusively staffed by volunteers. There are no volunteers, that's not an issue specifically here, but the point is the legislature bore in mind not-for-profits when they drafted this definition. Had they wanted to exclude boards of directors, either as a board or individual members, they had the power and the knowledge at the time to exclude it in that definition. They did not do so.
But your argument is not limited to nonprofits with regard to directors. I assume the same argument would apply for a profit corporation.
Right.
It may well, Your Honor, but quite frankly, we're here today on behalf of the members of a board of a not-for-profit. People who are
But in
volunteering.
theory, it is the same, isn't it, what Justice Gant says?
I believe it would be, Your Honor, yes. What we can glean also from review of that definition, in addition to the fact that it does not exclude the directors, is the general intent, the notion of what the legislature had in mind when they enacted the Workers' Compensation Act. What they were attempting to do was do away with piecemeal tort litigation, which was arising from injuries to employees in the workplace. And what they did was they balanced all of the interests of the various people in society and in the workplace, and they came up with a Workers' Compensation Act, which, as a quid pro quo, makes the job of the employee significantly easier if they are injured or die in the workplace. They don't have to prove causation. They don't have to go through all sorts of proofs that they would in a typical tort action. What the employer gets then is the certainty from a commercial perspective of what it's going to cost for them to run their business. Now, to try to separate the corporate governance body, the board of directors, from the corporation itself is effectively illogical. We know that from Boston Athletic Association that a corporation cannot act absent the guidance and direction of its board. We know that also from that case, that if the members of a board act in sufficient numbers, it becomes an act of the corporation. We also know from that case that that no individual director is capable of doing something that is an action for the corporation itself.
So are you saying, I'm trying to get to where the plaintiffs are and where the judge is as well. This concept of the directors are the employer, I mean, they're one and the same. So you would say that's as a matter of definition, so you don't have to show waiver? I'm just not clear what you do about this affirmative defense piece of this.
The waiver that plaintiffs brought up, we believe, is actually almost a non sequitur. The waiver comes up in a provision of the Workers' Compensation Act, which permits an employee to waive out of application of the Workers' Compensation Act scheme, and instead to reserve for themselves the right to resort to tort litigation in the instance where there's injury or death in the workplace. Factually, that couldn't have been pled here by the plaintiff because this employee did not waive out of application, and legally, as a practical matter, they didn't even plead it. So it's not our burden, it's not defendant's burden to raise that at some time in pleading, such as in answers in an affirmative defense. Instead, it simply is missing a standard of pleading, which is the plaintiff's burden in the complaint itself.
Judge Wilkins' decision seems to have turned on the idea that it's premature to dismiss the complaint, that this really should go to summary judgment, and we'll take another look at it then. He said that the complaint does not establish with sufficient certainty that the defense of workers' compensation exclusivity will prevail. Tell me why he wasn't right.
Your Honor, we believe he was not right because if you look at the specific allegations within the complaint in light of the standard which this court has set in Iachino, we do not believe that there are sufficient heft in the facts as pled, and that the only thing that there is really in the complaint are bare labels and conclusory allegations, which are insufficient to meet the Iachino standard.
But I take it your position's a little different. I thought you say, as a matter of law, the directors are the employer. So the allegations don't matter in that sense, do they?
We believe that is true, Your Honor, as well. That simply as a matter of law, that the employers, that was the intent of the legislature to contain within the definition of employers boards of directors.
So
But I take it.
Go ahead.
But I take it that a director acting outside of their role as a director or in violation of their fiduciary duties as a director who causes an injury to an employee, isn't that essentially what Judge Wilkins is saying might have occurred here, or at least it's significantly alleged or adequately alleged?
It's insignificant. It is not sufficiently alleged, firstly, Your Honor, in that there is not a circumstance where a director, as a director in casting his or her vote, acted in a manner which breached a duty which a director has that's recognized under law.
So it would have to be something far more than what is alleged here.
That's
An
correct,
act
Your Honor.
far further from the director's sort of corporate conduct.
That's correct, Your Honor. And if that were the case, then, for example, if there in fact were a fiduciary duty between an individual director of the board and this employee, that would have had to have been alleged. It's not alleged. The special relationship necessary to invoke a duty was not alleged here.
But aren't the plaintiffs, and I may be wrong about this, but aren't the plaintiffs saying that, look, there was a conflict of interest here between the vote that the directors took and the work, the business, the purpose of the corporation. And they were acting essentially ultra vires. They were acting outside the authority of the corporation. And it's that relationship, the nature of that particular vote or those votes and that activity that exposes them to individual liability that's not covered by the exclusivity provision.
But that, Your Honor, is not sufficiently pled, firstly, by the Inicino standard, in that there are insufficient specifics other than the conclusory allegation, as Your Honor just articulated, that there was a conflict of interest. There is no conflict of interest shown in the pleadings.
No, okay, so you're saying that it's not enough to allege that there was a conflict of interest. They really should have spelled out what the nature of the conflict was.
That's what Inicino says, Your Honor.
Okay.
Yes.
I'm a little bit lost now in view of what you've just said. Let us assume that they put together a complaint which says in extraordinary detail that the directors have their own incentives to get their patients into this facility, and regardless of the danger that they pose, and that they put together a set of rules which would make it easy for them to get their patients into this facility, which serves their interest as doctors, but perhaps not the interest of the employees of this entity. Assume that was done in great detail. Does the case survive?
Under those circumstances, it still wouldn't, Your Honor, we would contend, because there is not a duty recognized in law as between the directors, as individual directors or as members of the board of directors, to the employee. Therefore, if there is no duty recognized, there can be no breach of that duty.
Okay, so you're saying there's no breach of fiduciary duty there, but they've also maintained a negligence claim, and they say that that conduct takes them outside of the protection of the Workers' Comp Act because it's being done for their own benefit, not for the benefit of the corporation.
But, Your Honor, the comprehensive nature of the Workers' Compensation Act doesn't permit a negligence claim, whether it sounds as negligence, gross negligence, even willful conduct. It is included in the comprehensive nature of the remedies of the Workers' Compensation Act.
Maybe it's the same question Justice Gantz is asking, but I'm confused. If you're theoretically saying the employer, that the directors and the nonprofit corporation, North-South, are one and the same, identical, for purposes of the Workers' Comp Act, right?
Yes.
Well, then, wouldn't it follow that looking at whether an individual director or the director or more had breached their duties doesn't even arise? I'm just, where do you go from looking at the board and the entity as one to looking at the board members individually?
We don't, Your Honor.
No, but you answered Justice Spina and said, well, yes, if the pleading, if the facts were better alleged, maybe there would be a cause of action. So I'm just not clear how that works.
We don't believe that the courts need to get to this level of analysis at all. Things get confused because we're taking such a fundamental premise of the law, which is so clearly part of the intent of the comprehensive legislation embodied in the Workers' Compensation Act, and we're trying to drive a wedge in between two parts of an organization that are so inherently and immutably tied, its board of directors and the corporation itself. And in doing that, having what this complaint does, basically throwing the whole Workers' Compensation Act on its ear, we come up with certain issues which are perplexing, but they need not be perplexing.
But so it would be your position, let's just say, as Justice Gantz was saying, that you really did have a cabal among the directors who created this really reprehensible policy. I'm not saying that's the case, but totally reprehensible policy, no standards whatsoever. We don't care one bit whether our employees are safe or not. In fact, we'd like them not to be safe. And they implement that. There is no cause of action against them.
There were two things, Your Honor. Firstly, the duty of that board is to the corporation. The exclusive right in the Commonwealth to address an alleged breach of a duty of a not-for-profit by
For the
the
Attorney
members of the
General?
board is in the Attorney General.
So I take it then your position is that it doesn't make any difference what they do, so long as they did it while wearing the hat of the corporation. It is the act of the corporation for purposes of civil liability.
Well said, Your Honor.
For at least vis-à-vis an employee. No, I mean, I take it that's not true.
For purposes
Vis-a-vis
of
an employee
exclusivity.
because of the Workers' Compensation Act. If there
What
were,
does, and I didn't look at it again. What about the Wang case? Does that come into this at all?
I'm not sure.
You know, the person who was employed by Wang, and it was the plaintiff was suing because there had been an interference with contract?
There are a few isolated grounds where this court has said that there is a deviation from the Workers' Compensation Act. I think it's tortious interference with contractual relations, a few other things which are not employment, workplace, tort-related. But this, Your Honor, given the tragic nature of what happened here, this is clearly a tort in the workplace contemplated for coverage by the Workers' Compensation Act.
Your time is up. Thank you.
Thank you, Your Honor.
Good morning. Sean Regan, representing the plaintiff, the estate of Stephanie Moulton. Your Honor's in the courtroom with us today are Stephanie's parents, Kim Flynn and Robert Moulton. I also would like to begin by saying, may it please the court, but there's nothing about this case that should please the court. This is not a tragedy. It's a bloody murder. 7 days ago, Mr. Chappelle was convicted of that murder. The essence of the allegations that we're making in this case is he did not act entirely alone, that others, in this case the directors of the corporation, are complicit. They are complicit because they knowingly have taken many criminally dangerous persons, put them on the street, and put them in situations where those around them have no idea of the threat posed. They work through a labyrinth of corporations. Publicly available information would reflect that there are more than 10 corporations associated with North Suffolk located at the same address in Chelsea. They operate more than 20 pieces of residential real estate. There are at least 25 corporations associated with North Suffolk. And just last year, they pulled in more than $43 million in various state.
Are you suggesting that the directors are making a huge profit here, Mr. Regan?
I am suggesting this is very big business, and it offers a great opportunity for self-dealing on the part of the directors.
And that's what you're accusing them of?
We are indeed.
Okay.
We are alleging specific intentional acts in conflict with their duties as directors.
So would you say that any organization, nonprofit organization that serves this population of patient, insofar as dangers lurk, those directors would be equally liable?
Insofar as they may be trading on that position to take advantage of what amounts to a captive clientele for their personal practices, their personal businesses, and enterprises in the community, I would say, yes, that is the case.
Now, let's assume that everything you say is right. I'm not saying it is, but we'll grant you that assumption for now. And all of the conduct was committed by an officer as opposed to a director. Do you have a claim?
My understanding would be no.
And then if there's no claim, if it's done by an officer, why would or should there be a claim if it's done by a director in terms of the purposes of the workers' comp?
There's a well-established co-employee rule under workers' comp cases. Presumably, an officer is an employee of the corporation, just as Stephanie Moulton was. There is a distinction, which you were developing with my brother, between the corporation itself and the directors. Directors are subject to suit by the corporation for breaches of their various duties. That clearly establishes them as two separate persons or groups of persons.
Well,
Rightly or
so are
wrongly, the
officers.
co-employee
So are
rule may-
officers.
But officers are
So are
subject-
officers subject to suit for breach of their duties.
In that case, it may be that the co-employee rule will not apply. I'm just thinking categorically that we are not dealing with employees, in any sense employees of the corporation, when we're talking about the directors. And that is a clear distinction, and they are not in any common sense use of the word, the employer. They didn't pay Stephanie a check. They didn't direct her work.
Well,
They
they're not-
set up
Go ahead.
the game. I'm sorry, Your Honor.
No, you go ahead. I interrupted you.
If the directors had even allowed, much less required, that a proper examination be done of prospective clients, none of us would be here.
If there were no conflict of interest,
Yes, Your Honor.
but the vote of the directors was total incompetency, was based on total incompetency and in ignorance of standards, would you have a claim?
My claim would be much weaker. Whether it would survive or not, I don't know. But
So
it is,
but
the knowing conflict is the essence of our allegation, Your Honor.
but it's the action of the corporation as the employer
But it's the manipulation of the corporation by the directors, which is what this claim is about.
But the employer was the corporation.
Agreed.
And why aren't you bound by that fact, that the employer was the corporation, and your exclusive remedy is Chapter 152?
Because I'm not suing the employer. I'm not suing North Suffolk Mental Health Associates. And we're down now to the question of whether we can equate an individual director acting in his own interest with that corporation. And it's obviously our position that you cannot. They are distinct from each other.
So is the director part of the employer as long as the director is acting within a certain range of acceptable conduct, but then not the employer if they're acting outside?
I don't think an individual director is ever cognizable as the employer. The board, acting as a board, as the highest management body of the corporation, may be identified with the corporation.
So you would turn, if I understand the argument then, if no individual director is the board, for purposes of workers' comp, there is absolutely no protection for the directors, unlike anybody else.
I would say that's correct, Your Honor.
You
and
would say or would not?
I would say that that is correct.
So for purposes of workers' comp, just let me finish, it would be just the same as if, it is the case that if an officer or a director participates in a decision that causes injury to somebody who's not employed, there may be a personal cause of action. You would say it's exactly the same even though the person is employed by the organization.
Yes, with respect to the individual director acting in his individual capacity, yes.
So who in his or her right mind would ever possibly serve as a board member of such a nonprofit?
Anyone who is willing to fulfill their fiduciary obligations and not engage in self-dealing, Your Honor.
Oh, well, that's assuming, you're begging the question, right? You're going to get sued.
It's a question of evidence, Your Honor. The denial of the motion to dismiss has not established our claim. I still have a heavy evidentiary burden, and this is off the record, but we have done some discovery, and it appears to me that many of our allegations have been substantiated, including allegations of conflict of interest.
If a board member votes against the majority, is that board member nevertheless exposed to liability in the circumstances of this case?
I would say not, Your Honor.
And if a board member does not have a conflict of interest, but votes with the majority, is that board member liable?
I'm going to have to go down the list of 18 individuals named here, and for each one of them, it's going to be my burden to discover and to demonstrate the conflict of interest and to discover and demonstrate the manipulation. I believe I found it with several already.
But you've named every single one of the 18 as defendants, have you not?
Before discovery began, Your Honor.
And if the cabal of those with a conflict of interest does not in and of itself constitute a majority for purposes of board action, and others voted with the majority who did not have a conflict, is there still liability as to everybody?
That's another difficult factual question, because with respect to those who did act out of a conflict, those that did engage in self-dealing, I suppose it would be a question for the jury to decide to what extent, if any, that was instrumental in the subsequent actions and the subsequent killing. But at this stage of proceedings, Your Honor, the Workers' Compensation Act is not a bar to this action proceeding. I would suggest that the charitable immunity statutes, 231, Section 85K and 85W, provide, it's an analogy. In some sense, the legislature has already addressed what principles would apply. Those statutes grant a limitation of liability for charitable corporations and for their officers and directors. But each of them provides that if you have willful, intentional, bad faith conduct, that shield doesn't apply. Even if there was some protection afforded any place under the comp statute to individual directors, policy demands that you not provide a shield for willful, intentional self-dealing, which results in these types of injuries and death. Otherwise, you're granting a license to kill. And that is what happened here.
Now, help me to understand your claim. I understand your claim is that the medium of harm here was the operating policy and the admissions policy, that those policies were such that they permitted this individual to become admitted and resulting in the death of Ms. Moulton. That's a board act, correct?
Yes, Your Honor.
But because it is a board act, is it not an act of a corporation by its very nature, as opposed to an act of an individual director?
The answer is yes, but it is also, we allege, the product of self-serving manipulation by one or more of the directors. It is true that the Board of Directors sets the policy. Board of Directors could delegate to Director 1 the handling of the money. He might write himself a check and leave town. That's still an official action. He was delegated that job and he handled the power that was given to him. He just did it wrongly. The directors are delegated the job of setting policies, and they've done so.
And if they delegate it, this goes back to Justice Gantz's first question, they delegate the setting of the development and adoption of both the admission and operations policy to the CEO of the North Suffolk Center, there would be no liability. That's right? Even though that CEO may have conflicts up the yin-yang.
I believe that gets us into another factual question, Your Honor.
But
If it-
assuming
if it-
that to be the case,
if we
you would say
assume-
no liability, isn't
If
that
we
right?
assume that I cannot demonstrate self-serving manipulation led to these policies, I'm out. But I'm out at summary judgment time, or I'm out at trial.
No, I'm just trying to see if, make the point, I think, that I thought you agreed that if this was the president, an employee of the organization, who adopted was delegated the authority to and did adopt and pushed to the board unsuspectingly a policy that was incredibly unprotective of the employees for his own or her own interests, there would be no liability here in this case because it was the officer who was acting, correct?
If these policies are not the product of the director's conscious, intentional decision, I don't have a claim against them. Your Honor, I think, Your Honors, you've pretty much heard all we have to say. I take it that you have a good grasp of our allegations based on some of your questions, and I just ask your consideration and ask that you deny the appeal.
Thank you, sir.